Hello, my name is John Riley, and I'm an assistant professor of law at Sogang University in Seoul, South Korea. I'd like to briefly introduce to you my paper regarding Japan's monetary policy and its legality under international law. You can read the full paper. It's published by the Journal of East Asian International Law, Volume 7, Number 2. The crux of the issue involves a recent depreciation of the yen in the range of 25 to 35% against other major currencies, including the US dollar, the Chinese yuan, and the South Korean won. And certain industry leaders in these countries have accused Japan of manipulating its currency to gain an unfair competitive advantage. The monetary policy under attack is referred to as quantitative easing. It essentially involves the central banks buying assets from banks such as corporate debt, long-term government securities, or mortgage-backed securities, or other kinds of asset classes as well. But essentially the purpose is to free up the credit markets to get banks lending to each other and to get banks lending to businesses. Now, I argue that Japan has not violated international law with this quantitative easing program, either the IMF agreement or the WTO agreements. The first reason I think so is because it's difficult to prove a cause and effect relationship between the quantitative easing program and the yen depreciation. There are many factors that affect exchange rates, difference in interest rates, other quantitative easing programs by other central banks, appetite for risk, and things of this nature. And I found a number of economists and researchers that have concluded, including those at the IMF, that Japan's quantitative easing has had little, if any, effect on the depreciation of the yen. The second major issue involves the intent and whether Japan has a valid domestic policy reason for enacting its quantitative easing program. And I believe, like the many other central banks that have, including the US and Europe and England, they essentially want to, as I mentioned previously, free up the credit markets. And in Japan's case, they've had 20 years of deflation and economic stagnation, which Prime Minister Abe has promised to put an end to, essentially. So I believe that they have a very strong argument in that regard. And that's essentially why I reached my conclusion that Japan's quantitative easing program does not violate international law. And I hope you get a chance to read the full article at the Journal of East Asia and International Law. Thank you.